World Cybersecurity Forum is a globally prestigious cyber consultancy and web network that tends to create awareness to various internet issues and goes as a wellspring of techno-legal information for professionals, students, teenagers, and middle-aged civilians around the globe. While working on our vision to create cyber awareness, we have taken a step ahead. We have taken a step ahead and we have came up with the Acuity Moot Court Competition, which includes not only the Indian laws but as well as the international laws. We have received a registration of 42 teams and just two teams, that is TC20 and TC22, has made up to the finals after their hard work. So I would like to welcome all the judges as well as participants for their time and efforts. Firstly, we have Mr. Sebastien Lafrance, who is a prosecutor, Crown Counsel for the Prosecution Service of Canada since 2019, and he is a part-time professor of law at University of Ottawa. Welcome, sir.
Thank you very much. And since 2013, if I may correct you very, very respectfully. Thank you.
Okay. Secondly, we have Ms. Nino Goshkheteliani, who is in Georgia attorney at law, and she is information security officer at Bank of Georgia. Welcome, ma'am.
Thank you very much.
Then we have Ms. Bhavna Batra. She is a vice president of Amity Law Foundation, and she is also an assistant professor of law at Amity University. Welcome, ma'am.
Yeah, thank you so much. And I extend all my good luck to the participants. Do well and all the best.
Thank you, ma'am. Then we have Mr. Pedro Rogerio de Carvalho. He is an associate researcher on law and technology at ID Tech Brazil. He is also a co-founder of Public Interest Law Litigation Society. Welcome, sir.
Thank you very much for having me.
Now, lastly, we have Mr. Rishabh Gaikwad. He is an information security architect at Algamin Industries, Kuwait. He is also keenly interested in cyber laws and forensic science. Welcome, sir.
Thank you. Thank you so much for being on this panel. I look forward to the recent cyber laws and provisions that we have in order to mitigate.
Can we start the round?
Challenges. Yeah. Sure, please.
Prosecution can start.
Can the prosecution begin?
Yes, please.
Greetings to the bench. May it please the court. I'm the counsel appearing on behalf of the applicants. My submissions shall cover the contentions pertaining to the unauthorized access of data and data theft on part of the respondents. That is the first and the second contention. The remaining contentions pertaining to the constitutional validity of the Penguin encryption laws and the criminal liabilities arising on part of the respondents shall be dealt with by my co-counsel, and we shall each take 15 minutes to cover our pleadings. The counsel appearing on behalf of the applicants now seeks permission to collectively address the bench as your lordships.
Permitted.
Much obliged, your lordships. The counsel now seeks permission to begin advancing arguments for the first contention.
Please proceed.
Much obliged, your lordship. As under the it is duly contended before the Honorable Federal Court of Penglia that as under the provisions of the Penguin Information Technology Act, thereafter dubbed as PITA, a body corporate dealing in sensitive data shall incur liability for the processing of said data if the said processing is done in a negligent manner whilst not being able to maintain reasonable cybersecurity practices. In particular,
but sir, can I ask you a question here? Does it open any slight negligence to qualify as such? How do you establish the threshold, factually speaking, of such type of negligences in those cases?
The council understands the concern raised by your lordship. To answer, the council submits that the negligence shall arise. The bare minimum threshold for negligence shall may be interpreted on a case to case basis. However, under the current circumstances, a reference may be made to the moot proposition whereby the respondents have engaged in mass acts of data deletion, which may be the negligent act on part of the respondent, that is a body corporate, Waldorf and Co. Which may also point out to the act of flouting the provisions of the Penglia Information Technology Act on part of the respondents.
Thank you. You can proceed and keep doing your
Much
submissions.
obliged, lordship. In particular, a reference may be made to Section 43A of the Penglia Information Technology Act, whereby a body operate, i.e. Waldorf and Co., the respondents in the current case, dealing in sensitive data in a negligent manner whilst not maintaining reasonable cybersecurity practices, shall be liable within the provisions of Section 43A in case there's a wrongful loss caused to anyone to whom the data belonged, whereby under the current circumstances, the respondents dealing in their capacity as a data intermediary have engaged in acts of mass data deletion.
Let me ask you a very general question here, and I understand we're early in your submission, so I will allow myself to do it as the president of this panel. What kind of cases are we dealing with here? Is it a constitutional case, criminal law case, civil law case? And I'm aware of the facts, just so you know, but there seems to be several, if not a plenty, of various areas of law covered here. So can you just identify in a few words, no need to be thorough, but just every single area of the law that are covered in this case?
Your lordship, to answer your lordship's query, in the current case, the applicants have sought to move the Honorable Federal Court of Penglia under the prerogative jurisdiction of the Federal Court of Penglia under Article 32 of the Penglian Constitution, whereby the acts of the respondents have resulted in the violation of fundamental rights, violating data privacy of the citizens of Penglia, and the applicants have sought to move a public interest litigation on behalf of the citizens of Penglia for the said violations of fundamental rights of the citizens of Penglia, and under which, in particular, charges have been levied against the respondents under the following statutes, namely the Penglia Information and Technology Act, the General Data Protection Regulations, the Penglia Cybersecurity and Safety Act, the Penglia.
No, I understand. I will have to stop you here, sir. But my question was meant to be brief, as I mentioned it. So I just wanted to identify the areas. So I'm aware of the facts. I'm aware of the. You do not need to educate the bench about the law, and I know that this may not what you're doing, but briefly, because basically here, the leak of information or the deletion of information here, or what is sought after and for in this case? Is it a remedy such as damages or culpability in the criminal law area of Waldorf and the state, or like there seems to be several things before our court, and for it's not a matter, and I understand my question could have come across as a question about jurisdiction and all that, but it's really factual. I really want us all to be aware of all these areas, because that will come up and to be clear about them during the questions that will be asked and the answers that will be given. So this is only why. Be very, very brief, if I may ask, like criminal, constitutional, civil, if applicable, or privacy, etc. So, but just list them. But you did it already, so just go back to your submissions. For the sake of time, I don't want you to waste your time. But I understand that constitutional law is obviously involved, criminal law as well. But we'll move on to other areas if need be. But for the sake of time, again, just move on to your submissions. Thank you.
Much obliged, your lordship. Continuing with the first prong of the argument, the body Waldorf and Co. shall be liable within the provisions of Section 43A of the Penglia Information Technology Act for dealing with the data of the citizens of Penglia in a rash and negligent manner. Furthermore, engaging in acts of data deletion and modification of data without the requisite authorization, thereby making unauthorized access to the data. For the ease of reference of the bench, sensitive data under the current manner, as specified by the Penglian government under the Penglian Information Technology rules, shall include passwords, financial information, physical and physiological information, sexual orientation, biometric information, and or any other detail relating to the said information mentioned.
But do we know in the facts of this case, sir, what specific types of information have been leaked based on the facts of this case? I understand the section you're referring us to and the refresh demand at court, but what type of specific data are at stake in our case?
Your Lordship, under the current factual matrix, as per the schemes notified by the Penglian government, that is the sensitive information number and other basic details of the citizens of Penglia that were in possession of the respondents as a data intermediary.
And you will agree with me, sir, that all this sensitive information have been gathered by the state in order to fight corruption or help fighting corruption. Am I correct?
Yes, Your Lordship.
So, and what do you have to say about that? Or maybe it's your colleague who will address this issue, but if you are, just let the court know what your angle and views are about this.
Your Lordship, under the current circumstances, the liabilities that have been imposed, the data were collected by the state. However, the data breach that took place, the IP addresses involved in said data breach were traced back to the Dorota Internet Service Provider, which was allotted to Waldorf & Co. And Waldorf & Co. was the data intermediary for all of the transactions that took place, and Waldorf & Co. was acting in its capacity as a data processor as well. Owing to which liabilities have been leveled against the respondents under the current circumstances.
Well, Waldorf & Co., it's obviously not a state. So how do you establish the connection of the liability here? Because my understanding is that the state is one of the parties, not Waldorf & Co. necessarily directly. So what is your opinion about this or submission about this?
Your Lordship has raised a very pertinent question. Under the current circumstances, Your Lordship, in the scope of Penglian jurisprudence, Waldorf & Co. being a small financial bank, may be deemed to be discharging public duties, which may bring them under the ambit of state, against whom, for the breach of any fundamental right, an application may be moved before the Honorable Federal Court of Penglia within the ambit of Article 32, for which reliance may be placed on the judgment of R.M. Joshi versus Reserve Bank of India, furthermore relying upon the judgment of V. Ramaiah versus State Bank of India.
Counsel, could you let us know about the facts of the case that you just referred to so that we see the similarities or manage to distinguish it from the present case?
Your Lordship, the counsel appearing on behalf of the applicants had cited the cases under which, for the purposes of making a nexus between the respondent acting in the capacity as a state whilst being a data intermediary, that for the purpose so that a nexus may be established that an action can be brought forth against the respondents in the cited judgments that have been on which reliance have been placed under the factual matrix. It was an observation of the Federal Court of Penglia that a bank engaging in public duties may come within the ambit of Article 12, that is a state against whom constitutional remedies may be sought.
And sorry, you just mentioned the very important keyword intermediary. So is there any jurisprudence or case law or any specific definition of such a technical term?
And counsel, in conjunction to what the president is asking you, the similar question is asked by me also, that what is the relevance of the word intermediary, which is used in section 79 of the Act? So please specify the relevance of the word intermediary and relate it to your case.
Your Lordship, to answer the queries raised by your Lordships, an intermediary, a data intermediary may be as defined in the judgment, as in particular, a reference may be made to the judgment of Google India versus Visakha Industries, whereby an intermediary was defined as a conduit through which information may flow.
Counsel, instead of referring to the judicial precedents, let us come back to the statutory representation, as you have mentioned in your written submissions also, that you're trying to exempt intermediaries within the purview of section 79 of the Act. So please be specific with respect to the statutory interpretations.
Understandable, Your Lordship. As defined under the Penglia, as defined under the section 2 subclause W of the Penglia Information and Technology Act, an intermediary may be defined as any person who, on behalf of another person, receives, stores, or transmits, or records or provides any service with respect to which may include telecom services or web hosting services or search engine, online payments, online auctions and online marketplaces and cyber cafes, etc. And Waldorf and Co. acting under the current circumstances, being empowered by the empowered under the schemes notified by the government of Penglia, has been engaging as a data intermediary for the purposes of storing all the transactions in the data streams that may that have taken place in regards to the sensitive information number, along with other data that have other data of the citizens of Penglia.
Counsel, doesn't state have any sort of responsibility when selecting an intermediary? Is there any case law that you are acquainted with in that regard, or maybe statutory law?
Your Lordship, within the scope of Penglian jurisprudence and the Penglian legal system, there may not be there may not be any legal statutory requirements for the purposes of selecting an intermediary as such, which have been on place. Under the current circumstances, liability under the scope of Penglian jurisprudence, liabilities may arise in a post facto scenario whereby liabilities have been defined as negative charges that may be leveled against any person who may fall within the purview of the definition of an intermediary. Proceeding forth with the second prong of the argument, as under the provisions of the Penglia Cybersecurity Act, it is humbly submitted before the Honorable Federal Court of Penglia that within the provisions of the Penglia Cybersecurity Act, a person, any person which is an owner of a critical information infrastructure, as defined within the interpretation clause, i.e., section 2 of the Act, may be liable to furnish would be liable to furnish information if and when in regards to a cybersecurity incident, if and when requested by a duly notified authority, whereby under the current factual circumstances, Waldorf and Co., acting as an owner of a critical information infrastructure, was requested by the Director General of the Penglia Cybersecurity team to furnish information pertaining to the cybersecurity breach that had taken place, that had resulted in a gross violation of the fundamental rights of the citizens of Penglia, as well as a massive data breach that had taken place.
Counsel, I have a question. Does Penglia have a dedicated law on encryption?
Your Lordship, the Penglian encryption laws.
Are they all
yes,
codified or are they rules?
Your Lordship, to the query raised by Your Lordship may be answered in a more granular fashion by my co-counsel pertaining to the contentions in regards to the Penglian encryption laws.
All right, continue.
Much obliged, Your Lordship. if and when such owners of a critical information infrastructure are requested by a duly notified authority to furnish information, they are liable to furnish such information upon such request, whereby under the current factual matrix, Waldorf & Co. being an owner of a critical information infrastructure as defined within Section 2 of the Penglia Cybersecurity Act may be liable within the ambit of Section 20, subclause 7, for read in conjunction with Section 2 of the Penglia Cybersecurity Act for not furnishing said information when when they were requested to do so in the form of a notice being issued to the respondents and seeking technical assistance in regards to the cybersecurity breach that had taken place, whereby they were informed of the data in their possession being used for unlawful purposes. Moving on to the third prong of the argument, the respondent shall also be liable as.
How much time is left if there's a timekeeper? Can us know how much time is left?
We started 17, sorry to interject, we started 17 minutes ago, and as I remember, you requested 15 minutes to speak, counsel. Is that correct?
All right.
Yes, ma'am. Yes, ma'am. We have already undergo 17 minutes, and we have total 50 minutes for the prosecution.
So that was my point. Is there anyone who
But yeah, actually, what I will ask the Ms. Ahuja is I thought there was a bailiff or timekeeper, and that's very important in such a final. So I thank you very much to my esteemed colleague here to have raised this. I was not aware that time. That's much appreciated. But given that the first applicant took 2 additional minutes to what he was supposed to do, I will grant, of course, subject to the agreement of my colleague, but 2 additional minutes to the respondents as well for fairness. Of course, they are free to allocate these 2 minutes as they wish for the respondents, but if my colleague agrees, in all fairness, for the respondents, otherwise, or the second applicant may say that they will make 2 minutes less in their submissions. In such case, that would make it even with the respondent. But I will please ask the organizers to keep track of the time, because as judges, it's really focused on questions. If I may very respectfully ask on my behalf, the behalf of my esteemed colleague and esteemed colleagues as well. Thank you.
Thank you.
If your lordships may grant a small extension of time, the council, on behalf of the applicant, seeks a small extension of time for the purposes of quickly summarizing the points, the remaining points under the first and the second contention.
Council, I think with the consent of the president, we can't give council number 1 more time, but we will have to proceed to council number 2 if my bench agrees.
I agree.
Please take 1 minute to summarize, and then we'll move on to the second.
Much obliged, your lordship. Much obliged, your lordship. Moving on to the second contention, your lordships. A reliance may be placed within whereby the respondent shall be liable as an intermediary within the provisions of the Penglia Information Technology Act, in particular Section 79 of the Penglia Information Technology Act, whereby under the provision of Section 79, subclause 3, subclause B, an intermediary, upon being notified, possessing actual knowledge, and upon being notified by a government agency in regards to a cybersecurity incident that may have taken place, shall incur liability as an intermediary, whereby reliance may be placed on the judgment of MySpace versus Supercassette, whereby the Honorable Delhi High Court had laid down the test for distinguishing for determining what may constitute as actual knowledge. Your lordships, under the current circumstances, the test specified that an actual knowledge may be defined as an active constructive knowledge.
Sir, I will interrupt you. An additional minute was granted to you by one of my colleagues, but it was to summarize, not to keep making detailed submissions.
Absolutely right. You're not supposed to plead in the summary. You just have to summarize. Now we directly move to council number 2. And I think we can start with the next argument.
Much obliged, your lordships.
Thank you, sir. And thank you to my esteemed colleague.
Pleasure, sir.
Counsel on behalf of applicants now seeks permission to move on to contention number 3 of the argument, which states that the Penguin encryption law is not violative of fundamental rights as enshrined in Part 3 of the Constitution of Penguin. Now, it is humbly submitted that the Telecommunications and Other Legislation Amendment, Assistance and Access Act of 2018, also known as TOLA, on which the Penguin encryption law is based, is not unconstitutional, as it strikes a perfect balance between the fundamental rights of persons and killing state national security reasons. So it is well known that the increasing prevalence of encrypted data represents a significant challenge for law enforcement agencies to intercept anonymous cybersecurity threats and other such challenges. And as the cybersecurity threat took place on 29 February 2020 on the Penguin citizens, which resulted in the loss of data, loss of information, the risk of financial information. It also caused harm to the country's sovereignty, its national integrity, and also it led to mental harassment of the citizens as well. So to combat such situations, the encryption laws which are instituted by Penguin are necessary, and hence they pass the test of proportionality and constitutionality as well. I'd like to quote the Australian security.
Okay, the test of proportionality is coming from what decision? I know the answer, but you are expected to tell the court.
Much obliged, Your Lordship. In case Puttaswamy versus the Union of India, a landmark case, an iconic privacy judgment in the Supreme Court of India, took place in 2007, talked about the fact that, like any other fundamental right,
No.
including the right
Sir, I just ask you to refer to the decision, and even though it is a decision of the Supreme Court of India, the court, all members of the court are aware of this decision. So just identify the decision and please move on to your submissions. Thank you very much, sir.
Much obliged, Your Lordship. So in the instant case, to prove that the TOLA, basically the Penguin encryption laws, which are based on the Australian encryption laws, pass the test of constitutionality, we have to look at the test laid down by K.S. Puttaswamy versus Union of India. So an invasion of life or personal liberty must meet the threefold requirement of number 1, legality, number 2, need defined in terms of a legitimate aim, and number 3, proportionality, which ensures a rational nexus between the objects and the means adopted to achieve them. Now, the second point in this is definitely satisfied, as the state has a legitimate state aim. There's a severe threat of anonymous cybersecurity threats in the nation, as was seen in Penguin itself on 29 February. And a lot of terrorists and cybersecurity groups use encryption technology and free-to-use messaging platforms, such as WhatsApp, to carry out their tasks. And to combat threats such as these, the TOLA, which provides for industry assistance, which allows the government to...
I have a question, sir, since you're the second applicant, and this question burns my lips in the very beginning, so I have to ask you my lips. Actually, I have to. Is there any criminal offense here that was committed? And if so, which one or which ones?
In the instant case, Waldorf Company Limited is being charged under the Penal Code for theft, for fraudulent concealment, and removal of property. So under the Penal Code, constitutionally as well, since they invaded the privacy of the citizens, and it goes against the right to privacy under Article 21 as well. And of course, so there are penal and constitutional consequences to what.
Counsel, what about forgery and cheating? Are they not covered under your case?
And also, in addition to my very good question from my colleague, what about conspiracy that is also clearly showing in your memorial that you kept absolutely silent here?
Absolutely, yes.
Yes, Your Lordship. Yes, Your Lordship. We are also charging them from criminal conspiracy and to be held liable under Article 120B. And I'm going to get to that point in my fourth contention as well.
Counsel, my question is, sorry if I may have a question from the counsel, with your permission, sir.
No, please go ahead.
Counsel, I just want you to know and let us know, how can you define a reasonable statutory provision? You have mentioned that in your written submissions. Just define with an illustration the meaning of the word reasonable statutory provision.
Yes, Your Lordships. So the industry assistance which is provided by the Penguin encryption laws, which allows the Penguin government to gather information from technology companies in order to get information which might hold evidentiary value to a case which might threaten the sovereignty of the country, which might threaten foreign nations, which might threaten economic security. And hence, since these laws carry such a, they have a rational nexus between what is supposed to be achieved and what and the procedure used to establish it is fair, just, and reasonable. Since the consequences of not having such a law would be dire and would lead to the loss of the denial of fundamental rights of citizens. And I like to also point out to the fact that the government of Penglia has initiated the policy in its policy decision, the decision to allow SIN numbers to everyone, and hence everyone's financial information is stored in the CASIN database as well. And this database is protected. We do have security practices and procedures. We have implemented ISO 270001 as a basic perimeter for protecting and preserving the cybersecurity of the data. And since we already hold sensitive data of citizens in terms of the personal information and financial information, and we respect their privacy, and we won't ever endanger their privacy and and allow cyber criminals.
Sir, you took too much time. The question of my colleague, esteemed colleague, was very specific. I will ask you to focus your answer when a question is asked, and the question was very narrow in order that was calling for a very specific answer, and you kept elaborating and moving on. So it's hard for the court. Not saying we didn't understand you, we did, but you elaborated too much. Please be a bit more focused in your answers.
So you can continue with your next submission because your time is less now.
Much obliged, Your Lordship. I'm seeking the permission to move on to contention number 4, wherein it's talked about Waldorf Company and its officials can be prosecuted for conspiring.
Please do. I have a question. Actually, before you start, I have a question right away. Can you what are? Oh, I will go even more directly, and I expect a very, very focused answer. So you are alleging in your memorial that there is a conspiracy in this case. You provide the element of the offense of conspiracy, which are basically summarily the same in all Commonwealth countries, including India, Canada, Australia, New Zealand, etc. So these elements are found in most, if not all, Commonwealth countries. So, or in common law countries to make it larger. But so where is the agreement between the parties in this case? Because this is one of the essential elements of the offense. Where is the agreement, or called otherwise in criminal law in many countries, including in India, the meeting of the minds?
That's a very pertinent question, Your Lordship. To answer this, I'd like to point out to the fact that an agreement between the parties can be inferred from their actions. And this has been inferred by the fact that that Waldorf Company Limited has engaged in the destroying and deletion of the data of the users, as well as failed comply with the due diligence procedure set out by the government. This showcases their intention as even as an intermediary. Conspiracy can be proved in the instant case.
So basically, you're saying that all the agreements, so basically they agreed to do something, but all the agreement itself has to be inferred and just based on the consequences of the actions. This is what you're saying. It seems to be a bit weak to me in light of the jurisprudence of several Commonwealth countries in such a field.
I I'd like to place reliance on this case called State of Maharashtra versus Somnath Thapa, in which for a person to conspire with another means he must have the knowledge of what the conspirators are wanting to achieve, and thereafter have the intent.
Oh, there we
now,
go.
To prove
But
this
you know,
knowledge and
sir, you pointed it out. How do you prove knowledge if it has to be inferred? I
Yes,
don't
Your
say it's
Lordship.
impossible, but I would like to, like, that's the thing that's missing here, perhaps in your submission, that I would like to know about.
I'd like to draw the bench's attention to paragraph number 10 of the moot proposition. So DISP, the Dorota Internet Service Provider, was allocated to the Waldorf company. That's the first indication that they might have knowledge of what could have been taken place. Thereafter, they were given a technical assistance notice by Vanderson, the Director General of PCA. And hence, after this, it was given because they earlier had encryption technology and data could not be revealed, which is necessary for the government to tackle the case such as this. And after that, it was found out that Waldorf Company Limited has destroyed some of this data and had also disallowed access to this data. And in this, I'd like to point out the fact that since Waldorf has engaged in the destruction and deletion of data when they did not have the prerogative to do so, it reveals some sort of intention and knowledge of their part to whatever happened on 29 February, which led to a massive data breach. And this proves criminal conspiracy on their part, as well as theft, which I will get into later on in my submissions.
Council, may I pose a question? We do know the IPs of the from which the cyber, can you hear me fine, by the way? Can you hear me?
I'm just having a bit trouble.
Okay, I'll just raise my voice, I'm sorry. I would like to ask whether the human-machine gap that exists in this case, that is, we don't know the identity of the persons who used the computers from which we know the cyber attacks were launched. So this is a human-machine gap situation. To what degree can this, to the degree that it can, to what degree can this human-machine gap shield the defendant from criminal liability?
Yes, Your Lordship. To answer the question of corporate criminal liability, I'd like to refer to the case Iridium India Telecom Limited versus Motorola Incorporated, in which the Supreme Court held that corporation can no longer claim immunity from criminal prosecution on the grounds
I will stop you, sir. I will stop you here. This is not the question. The question is more specific. If you need my esteemed colleague to repeat his question, I will ask him to do so if you need to hear it again and refer. But to me, the question was clear, and I'm convinced it was clear to you.
Yes, Your Lordship.
Thank you.
I was having some technical glitch, so please, could you repeat the question?
Of course, Counsel. My question is more to the fact that we do not know the identity of the persons who originally launched the cyber attacks from the IPs, from the computers that were traced to Waldorf Co. So the fact that we don't actually know the identity of the original perpetrators hamper in any way the qualification of criminal liability of the defendant in your contention?
Yes, I understand the issue, Your Lordship. In the instant case, however, there are the actions of Waldorf Co. Limited and how the events have transpired in the instant case prove to the fact that Waldorf Company Limited, directly or indirectly through their employees or as a whole, was involved in this criminal breach, which resulted in the loss of data of the citizens. So I'd like to point out again to the fact that Waldorf Company Limited engaged in the deletion of data of the citizens and the removal of data of the citizens when they did not have the prerogative to do so. And despite the fact that they have encryption technology, which is only there in order to protect the citizens, breached the very same. And it was done after the government asked for a technical assistance notice so that evidence could be gathered in the instant case. However, it proved difficult for them since they had already destroyed and deleted some of the data which might have been relevant to the instant case. Hence, all these facts prove to the contention that Waldorf Company Limited was somehow indirectly or directly through their employees or as a company itself was engaged, had the knowledge and intention, and therefore engaged in criminal conspiracy.
Well, you're saying it directly or indirectly. Which one? Because it cannot be both, actually. In such a case, it has to be one or the other.
I agree to that, Your Lordship. I would like to amend my statement and say there is a direct involvement, since even if the involvement is through their employees, they still have to concede some liability in this case. And if the company was acting as a whole, then too the liability is direct.
Counsel, do you think there are also certain exemptions from the liability under the statutory provisions?
I agree, Your Lordship. In the section 79 of the Information and Technology Act, an intermediary has been given exemptions in certain cases. However, I'd like to point out to provision number 3B, in which the last line is extremely essential. The intermediary fails to expeditiously remove or disable access to the material on that resource without vitiating the mandants in any manner. In the instant case, as I have already reiterated, that Waldorf Company Limited engaged in data deletion and data removal when they did not have the prerogative to do so. Hence, they do not fall under this exception and could be held liable as an intermediary. And in this case, their penal consequences are clear, since they have the criminal intention and the knowledge as well. And they do not have any exemption under this under the umbrella provisions of this act.
So how much time is left? Can the timekeeper let us know for this counsel?
Ma'am, it's 15 minutes.
15 minutes, including the rebuttal.
Okay, all right.
Okay. Now, the council now seeks to move on to prove the liability for theft for Waldorf Company Limited. So theft is defined under section 378 of the Pengalia Penal Code. It says whoever intending to take dishonestly any movable property out of the possession of any person. The keyword here is movable property. Now, the contention from the...
So the keyword is movable property, you say? So there's some technical issues for the, unless it's me, I don't think it's me, but there, okay. With counsel, there seems to be some issues.
I think
Technical,
yes.
Of course.
I think his screen is freezed or something like that.
Yeah. So for the sake of time, I will just ask the timekeeper to stop counting the time at this very moment. So the second applicant is not penalized because of a technical issue.
And if there is a team buddy or somebody who can check it from council number 2 of TC22, if there's a team buddy or a mentor to the team, and let the bench know if the feasibility of joining is within time, then we can wait. Otherwise, according to brevity, we can continue. So if somebody can just quickly let us know.
Yes, ma'am, I'm checking it.
All right, thank you.
Thank you. Thank you to my colleague for this initiative.
Thank you, sir.
That's perfect. So we have a message just for the record, because people may not see what's typed. Where judges are asked to wait for 2 minutes. It is being sorted out right now. So I will ask everybody's patience and people to, all of us, including my esteemed colleagues, to hang on and wait. Thank you very much.
The council will be joining us shortly. I've just received their message.
Excellent. Thank you very much.
Your Lordship, would it be possible to allow the council to join using his mobile, as in a different device?
I don't see any issues as long as he comes back to us. And
Right.
of course, if the sound is of sufficient quality to allow judges to ask questions.
Yes, yes.
I'm terribly sorry for the delay caused, your lordships.
It's fine, no worries. It's understandable and it's all good. So you started talking about theft and addressing this part of your submissions. By the way, I will ask the timekeeper to start and resume the counting of time from this very moment. You had about perhaps 14 minutes for the 13 minutes left. I'm not gonna ask how much time was left to you. You're supposed to know, but the person who keeps the time should be aware that now it's time to start it. Yeah, before you move on to the item of the theft, in this case, I would like to bring you back to your memorial, if I may, to paragraph 50, where you basically cite a Supreme Court of India decision, seminal decision of Rajiv Kumar versus State of UP. And you will remember you answered the question regarding the agreement by suggesting to the court the existence, in this case, of an agreement that would need to be inferred. But in this case of the Supreme Court of India, and it's not necessarily conflicting with what you're saying in law, but in fact, I'm not convinced by your submission, and I just would like to point it out, because the Supreme Court of India stated, based on your quote, the essential ingredients of the offense of criminal conspiracy are I in Roman letter, an agreement between two or more persons, and two in Roman letters. The agreement must relate to doing or causing to be done either an illegal act. So there must be another way. The Supreme Court of India tells us that the agreement must be specific. They say it in different terms as a legal test. But how is it possible to know what was the intention of the agreement itself specifically when it has to be inferred and only based on the consequences of the actions? I see here a huge problem in terms of, because otherwise that's a possible floodgate of diminishing the burden of the Crown. And in my previous life, I was a prosecutor, so I have a tendency to be inclined to be in agreement with them. But here, even though it is so outrageous, to be very respectful to your submission, that it could open the floodgate and diminish so much the burden of proof for the Crown that any conspiracy of any kind could be proven before a court. So I would like to hear more about this.
Much obliged, Your Lordship. So in the instant case, since the issue here is that not enough evidence to the fact that the Waldorf Company Limited had knowledge or any intention or any agreement between them and the perpetrators to commit this act. However, they enjoy this exemption. They enjoy this exemption from liability as an intermediary due to the provisions in Section 79 of the IT Act, which gives them provisions. However, these exemptions are taken away if certain acts are committed by the intermediary. In the instant case, the intermediary has engaged in destruction, the deletion of data, which goes against the provision of 3B of this particular statute.
I understand, but they agreed to do what? And who agreed? And they where is any sign of an agreement? Is there any accord or a meeting or whatever in the facts? I didn't see any. So how can you support the existence of a conspiracy in this case?
The council only relies on the fact that
the second applicant's screen froze again, so I will ask the timekeeper to stop the counting of time as really right now, if I may ask. And for the record, we are told that the second applicant is left with 10 minutes. I understand that includes rebuttal, or does it?
Yes,
if
sir.
I may ask. Okay, thank you. So a total of 10 minutes is left to the applicant. So I will ask everybody again to be patient and of course to not penalize the second applicant for this technical issue or glitch, since this happens and it's not the first time it happens, unfortunately not the last. We're not in the 25th century yet. That's not knowing actually if that will be solved in the 25th century, but I will please ask everybody to be very patient and not and my esteemed colleagues to not consider this technical glitch in their assessment of the applicant. Thank you.
And I totally agree with the President that these are the challenges which we are facing in an online virtual moot court competition. And even if there's a statutory provision of time barred, in this case, still the rules of equity and good conscience may prevail over the statutory provisions of keeping it time barred, though already we started on time at 12. And if it's a 50 minutes job, then we are already done with the statutory time bar provision. But as President rightly said, that we are now fighting in jurisprudence over the conflict between statutory laws and morality, and keeping in view the natural justice, because we all are people from the legal fraternity. So keeping in view the natural justice and the principles of equity, good conscience and logic, because we all know common sense of law is logic. So keeping that in view, we are still giving time to the applicants. But yes, this is the last time, President. If again same thing happens, then we should give the chance to the other team, or we can directly, I think, initiate with one counsel and we can summarize the pleadings. Thank you.
I do agree, and actually it's very well said. So I thank my esteemed colleagues for this intervention. So if the applicant's screen were to be frozen, the court, based on my authority as the president, the court will order that submissions move to the respondent's side. So we can see the second applicant. I will ask him if he can hear us.
Yes, Your Lordships, I'm terribly sorry once again, but if I could just conclude my argument.
Yes, please do. And just so you know, if this technical and as my esteemed colleague well said and suggested, I will not rephrase what she said because it was too elegant, and rephrasing it would be an insult to the genius of what she just addressed and discussed before the court. But just be aware that if such technical issue would happen again, we will have to move on to the respondent submissions. But don't be stressed out by this. Focus on your submissions, and you may move on to giving the answer to my questions that I just asked.
Yes, Your Lordship. To ascribe intention knowledge on the part of Waldorf Company Limited, their intention to further abet or help in committing the act of the cyber criminals and the cyber phishers has to be ascertained. And this particular factor can be ascertained by the actions of Waldorf Company Limited. And since their actions pertain to the fact that they somehow, they had the knowledge of the data breach which has taken place, and despite that fact, they did not open their electronic protection in order to allow the government to gather evidentiary material, proves to the fact that they engaged in abatement of the crime which had taken place on that day. And hence, this ascribes a sort of liability and as knowledge to the to Waldorf Company Limited and its officials. And hence,
how? Because what you discussed so far is the actus reus. So how is their knowledge proven here, and how this knowledge connects to the agreement itself? Because knowledge and agreement is not the same thing necessarily, and here it's not. So how can you be more specific? If you cannot, it's fine. I will ask you to move on. I don't want you to be trapped, because I've been focusing on this for some time, and of course my esteemed colleagues may have, and I may have, more questions about your other submissions. So if you cannot be more specific about the agreement itself, I will ask you to move on. And unless my words were so frightening that the screen of the second applicant froze, which I doubt, because I'm not that mad of a person or mean as a person, it's probably a technical issue. So in this case, as well said by my esteemed colleagues with whom I agreed, and then it became a potential order of the court. Now it will be an order of this court. we will move on to the submissions of the respondents. So the first respondent is now welcome to take the podium, virtual podium, and start their submissions.
The counsel for the respondent humbly seeks permission to refer to this honorable court as your lordship.
Yes.
Oblige, your lordship. The counsel for the respondent humbly seeks permission to commence with the statement of jurisdiction. It is humbly submitted that the respondent here has approached the Honorable Federal Court of Anglia under the jurisdiction of Article 32 of the Constitution of Anglia. The counsel for the defendant reserves the right to contest the jurisdiction and sets forth the facts, the contentions, the arguments in the present case. The counsel for the respondent humbly seeks permission to bring about certain key facts to this case to the attention of the court. Much obliged, my lord. The counsel would like to now talk about three key facts of the case. Firstly, Waldorf Company here is a banking company which deals in financial services with its respective customers. Secondly, that in the state of Anglia, there is only digital transactions allowed. And that is because due to the government mandate, and all this respective data of the citizens is stored in the CASIN headquarters. And thirdly.
Counsel, my first question is, how are you seeking exemptions under the Pengalia Penal Code? Just briefly summarize it quickly.
My lord, the counsel is submitting in the present factual matrix how in our arguments we do not meet the essential ingredients to be prosecuted for the same. Hence, we will deliver such in our arguments. The counsel will also.
Are you trying to tell the court that you are exempted to be an intermediary?
No, counsel, we talk about how under Section 2, Subclause 1, Subclause W of the Penglia Information Technology Act, how we meet every essential of to be an intermediary. Also, the counsel also seeks to continue with the issues. Moreover, the data theft and the alleged stealing of data is merely alleged, and there is no conclusive proof for the same. The counsel would also like to bring another fact to the attention, which is when the PCA officials issued a notice of to decrypt our respective data. It was well within our rights to withhold the same, as we are given the same right to privacy under the encryption law. Now, the counsel seeks permission to commence with the statement of issues. The first issue and the second issue will be dealt by.
But before, I'm sorry to interrupt, but you addressed well, I will let my colleague ask a question, but then I want to ask you a question regarding Section 2, paragraph 1W. I have a specific question to ask you about this, but I will let my colleague ask her question first.
I rather had a request for the counsel to slow down a little bit so that it's easier for us to follow your submission. Thank you.
I agree, and so orders the court right now for you to slow down your pace. I'm in the same boat and totally understand my esteemed colleague's request, so the court orders.
Much obliged, my lord. The first issue, whether the defendant has made unauthorized access and stolen the private data of the citizens. Second issue, whether the Waldorf Company has been assigned the DISP qualified to be exempt from liability as an intermediary under Section 79 of the IT Act. Third issue, Penglia encryption law is unconstitutional. Whether the Penglia encryption law is unconstitutional. And fourth issue, whether the Waldorf Company and its officials can be prosecuted for conspiring for the breach under relevant provisions of the Penal Code. My lords, the counsel one will be dealing with first issue and second issue, while the counsel two will be dealing with issue.
Before you do that, sir, I would like to ask you my question, and keep in mind to slow down your pace. Regarding Section 2, paragraph 1, subsection W of the Penglia Information Technology Act, are you aware of any decision that discussed the same or a similar legal provision? Or more specifically, is there any Supreme Court of India decision that addresses it?
My lord, the counsels in our arguments will be substantiating the same using Article 12 of the European Union Directive. However, the counsel seeks to bring this up during the second issue in furtherance of the arguments. The counsel
how does this answer my question, if I may very respectfully tell you? Maybe I misunderstood your answer, but it seems to be not answering it.
The counsel seeks to the lordships that the defendants may get back to the lordships with a specific judgment towards the end of the argument.
Oh, okay,
counsel
okay.
will-
Well, I
Okay,
would
okay.
like to know. I would like to know now if you are aware of this. Like the court is not here to weigh. The court is here to address the issue.
Absolutely. I even agree with the precedent that the counsels have no right to make us wait till the end point of the argument and then answer to our questions.
The council isn't aware of the council isn't aware of the specific judgment, but moreover, the council will prove how it is an intermediary using legislature as brought up in the respective arguments. Now,
So just to be clear, you're not saying that there is no decision. You're just saying you're not aware of them, right? If any.
There is a decision, my lord, which is the Bajaj judgment. However,
That's fine. You can move on. You answer my
yeah.
question. I know exactly what this decision is, and of course the court is aware of this decision. So thank you. I will ask you to move on and go back to your
Counsel, in
submission.
that case, don't let us wait. Please plead ignorance. Thank you.
Sure. Honorable Court, the defendants have not made unauthorized access and stolen the private data of the citizens. This is the first issue. Now, firstly, my Honorable Court, for a crime, there should be an actus reus and a mens rea to be prevalent for the crime to be established. My lords, in the present case, firstly, the defendants have not made unauthorized access, as unauthorized access is illegitimately without the permission of the owner accessing the computer system, computer database, or a respective server system without the permission of the owner. My lords, the prosecution has failed to prove from the factual matrix how there is a specific actus reus on behalf of the defendants. Moreover, my lords, the defendants here, my clients here, are walled off at the wall is a small financial bank. They do not have any knowledge of the same, and we contest that we are a victim of IT spoofing, of how we are alleged to how our IP address is used to hold us guilty for the same. However, now the council will also talk about.
There may be a question from. I don't want to put him under the spotlight, but there may be a question about this from my colleague. His Honor Rogerio de Carvalho. If I may ask him to maybe
yes,
to
I
ask
would
a
like to
question.
pose this
Thank you.
question we were discussing because of the memorials, actually. In your memorials for the same contention, you claim there was an issue of IP spoofing, and also there was an alleged DDoS attack. Later, I think in your paragraph 31, you also mentioned this same DDoS attack was similar to a zombie botnet attack, making the defendant's computers, puppet computers. The problem is, counsel, that these contentions seem not to be based in the facts whatsoever. So to what extent is this unwarranted, or should I say, to what extent is this inference of the case completely unwarranted? Is it not made up?
Duly noted, my lord. My lord, we humbly submit firstly that counsel 2 in his third issue will elaborate further on this. Also, we would like to talk how in the entire process of a system connecting to the internet and reaching its end source, there are numerous situations where there is scope for ambiguous actions to take place. We submit that there is no proof from the factual matrix to prove conclusively that we are the perpetrators in the respective case. Moreover, we would also like to submit, my lord, the very element of mens rea or dishonest intention under our present case.
Yeah, but sir, why did you mention the existence of a DDoS attack when there is no such fact in the facts of our case? To complement, though, to basically add to my esteemed colleague's question, we may have the same question here, and I don't want to go ahead.
My lord, in the factual matrix, it is given that the ISPs which they were traced for the respective attack were allocated to the Waldorf company. So the counsel is humbly submitting that the client has no knowledge of the same, and the said ISP has been used by an unknown perpetrator to carry out the said attack. the main contention of the prosecution is that the 3 ISPs were allocated to the Waldorf company, my lord. Hence, we humbly submit that there is no knowledge of the same, and we have not intentionally or committed the said act, my lord. Now, the council seeks to bring in
while it's my personal opinion that that's not very convincing at this point in time. Maybe your colleague will bring up further arguments. But what do you submit was respondent's obligation? What was the scope of respondent's obligation to ensure cybersecurity? Even if the respondent was a subject to cyber attack, doesn't the respondent have obligation to ensure its own cybersecurity? Could you elaborate on that, please?
My lord, the respondent here is a financial company, and the priority here is the security and data of its respective data owners and the data subjects of the users of the respective bank. Our company has taken due diligence with regards to the same, and we would like to talk about how there is a very lack of evidence from the prosecution side, to which we will draw.
Counsel, when you refer to facts, like you just mentioned due diligence, could you refer us to the facts of the case so that we know for sure that it's given in the problem?
The company the director of the PCA had contacted the respective company, and we cooperated to the extent until they asked us to remove our encryption technologies to release the specific data. However, we simply, it was our legal right to refrain from doing so. So the council now seeks to proceed further with the arguments.
I apologize. I think we're talking about different points in time. My question refers to before the data breach happened. You're alleging that respondent was a victim of a successful cyber attack, right? So before the cyber attack, doesn't respondent have an obligation to have proper cybersecurity controls in place to ensure that such cyber attack doesn't happen? And even if it happens, then what are the obligations of the respondent? What are the liabilities?
My lord, we humbly submit that right now, according to the factual matrix, the respondent is in compliance with the GDPR provisions. Namely, A, we do not tamper with our users' data. B, we do not let third parties access our respective users' data. And C, we collect it with the respect of their consent. So we are taking due diligence with respect to the same. Now, the council seeks to talk about the very important matter of evidence, my lord, to which we are going to talk about Wynn's law on circumstantial evidence. The council seeks to draw the attention of the court to para 5 of the moot proposition. The circumstances alleged as the basis of any legal inference must be strictly and intuitively connected with the factum probandum, and the onus probandi is on the party who asserts the existence of any fact which infers legal accountability. My lord, in the present case, the prosecution has failed with these two metrics, and has not conclusively established how we as the defendants are guilty for the same. Moreover, we would like to submit with the reference to the factual matrix, page 3, paragraph 7, how the respective data, how this data of the stored in the CASIM could be accessed by multiple sectors, the health sector and the IT sector. This leaves multiple permutations and combinations for the data to be accessed, my lord, and how this data could have, this data itself could have been accessed by numerous people, and it itself cannot shift liability solely on the defendants. Moreover, my lord, the council will now like to talk about how the very section of 378 of theft and section
Council, Council, please take into consideration our request to slow down so that it's easier for us to follow what you're saying. It's important for us to understand. It doesn't matter how much you say if we don't get it. But you just mentioned that the prosecution cannot sort of you just mentioned something that hinted at shared liability. Could you go back to that point, and to what extent do you allow that the respondent might be liable in the case at hand?
It was a slip of the tongue. Apologies, my lord. What the council meant to signify is how this data could have been accessed by a numerous number of people, and how it is unfair itself to blame the defendant for the same, my lord, as the defendant itself isn't as the data itself could be accessed by numerous people.
Could you refer us to the facts of the case so that we can see what you're basing your argument on?
My lord, page 3, paragraph 7, the data stored could be accessed by the IT and healthcare sectors. These are two numerous large sectors which have multiple facets accessing the said data, my lord. Hence, it would the Waldorf company is a small financial bank, and it does not have any intention or motive to carry out the said act, or to do the said action, my lord.
Just the mere fact that it's a small financial institution doesn't really provide sufficient proof that it wouldn't have any intention to benefit from the sale of such sensitive information on black market. Could you elaborate on that a bit more, please?
The council humbly agrees to the same as brought up by the lord, by my lord. But however, we submit that Waldorf, that this data hack has not been committed by Waldorf, as the evidence fails. There is not enough evidence for the same, and this could have been done by numerous other people or anyone else. That's what the council is humbly submitting. Moreover, the council.
What's the standard of proof that would satisfy respondent in the case at hand? So you're saying that. Yes, please proceed.
The onus is on the party alleging legal liability, my lord. The burden of proof is on the prosecution, to which they have failed to meet. Hence, it is beyond reasonable doubt for us to claim we should claim our innocence. Moreover, the council seeks to talk about the very important issue of applicability of Section 378. My lord, we are going to talk about how the very essential ingredients of intention, movable property are not met with regards to Section 378 of the Penal Code with the help of a case law. This Section 378 regards theft of the Penguin Penal Code, which is whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves the property is said to have committed theft. My lord, I'd like to draw your attention to Section 24 of the Penguin Penal Code, which talks about dishonest intention, which is whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person. My lord, we humbly submit, and if it pleases the court, that our defendants have no
Counsel, this is the last time the court will ask you. I did ask you, my colleague did ask you very, very kindly, and now I'm ordering you firmly to slow down your pace.
Duly noted, my lord. We humbly submit that the Waldorf company here has no intention to carry out the same. There was no knowledge of the said data breach. The very concept of intention that was brought out by the prosecution was us not allowing the decryption of the encryption technologies, which my co-counsel will elaborate on further. However, we humbly submit that this itself cannot be the very test for intention, as it was our legal right to do so, and we are conferred under the right to privacy under Article 21 of the Constitution. Moreover, the most important aspect of Section 22 of the Penguin Penal Code, which regards to movable property.
When you refer to Section 21 of the Constitution of Bengali, so of Bengalia, which is perimeteria equivalent to the Constitution of India. So what is the legal test decided and set out by the Supreme Court of India about this, about the right to privacy, for example?
This was held if the data is the triple test, my lord, where if the data is collected for lawful purpose, for lawful mandate, and if it is collected with the consent of the owner, and this was elaborated in the Puttaswamy, the KS Puttaswamy versus Union of India judgment.
There you go. But this is my question. So the famous case of Puttaswamy, which all everybody who is aware of the law in India should know about this famous case. Wasn't it a case about freedom of expression and not exactly related to the facts of our case? I don't say it is not applicable, the principles are not, but the fact that it was a case about freedom of expression, doesn't it make it distinguishable from the present case here? Maybe not, but that's my question.
My lord, the main principle of the case is how data collected should be done in a reasonable, just, and fair manner, and how the Waldorf company had satisfied the same, my lord, how we were complying with the same, but we also had the legal right not to disclose, and the judgment also talks about natural liberty, to which the clients are entitled to. My lord, I'd like to also talk about movable property here. Now, in the case of Avtar Singh versus state of Uttar Pradesh, it was held that the theft of electricity won't come under the definition of movable property as under section 22 of the Penguin Penal Code, and extension section 378 of the Penguin Penal Code. And why was this held so? Because electricity is intangible, it's imperceivable, it needs a medium to move, and moreover, it can't be seen. My lords, we humbly submit that data and electricity have similar properties as they both require a medium of transportation, are intangible, imperceivable, and hence it does not come under the very definition of movable property as it is.
So by counsel, based on your submission, would it be fair to also submit to the court as a side note that love is also a movable property, because it could meet the legal elements of what you just told the courts, wouldn't it? Could it be considered as a movable property? It's intangible, it's etc. So all these, what's your answer?
No, counsel begs to differ, my lord, because love is not a quantifiable quantity.
Thank you. You answered my question. Thank you. You answered my question.
Now coming to the next, so we have proved with the help of how the very essentials of theft is not met with the current case. And now the counsel also like to talk about, the counsel seeks an extension of a few minutes.
Counsel, your time is up. I understand that this considers the 3 minutes. Am I correct? I will ask the person who keeps the time to let us know. Does it count the 3 additional minutes?
Yes, sir.
Okay, so counsel, I will ask you to stop in all fairness for the applicants, because of course we cannot go back and give more time to the applicant. I will ask you to summarize in 30 seconds, no more, your submissions, and then we'll move on to the second respondent. Thank you.
We humbly submit that we do not meet the elements of theft under section 378 and of the penal code. Moreover, we do not have knowledge of the actions. There is inconclusive proof to show that the defendants are liable of the same. Moreover, the defendants here are an intermediary as under section 2, subclause 1, subclause W of the PITA, and the defendants here have had no knowledge of the said actions. The defendants here have had no guilty intention and no motive to carry out such a heinous crime and disable the protected system of society, and hence the council humbly submits how the defendants are not liable for the same.
Thank you.
Thank you, counsel.
Counsel seeks permission to refer the bench collectively as your lordship.
Yes, please.
Much obliged, your lordship. The counsel would like to proceed with the third issue, your lordship. Much obliged. Your lordship, the matter at hand is whether the Penglia law encryption is constitutional or unconstitutional. So the counsel will put forward the arguments in twofold manner, explaining that this law citizen with the contravention to right to privacy in the first part. Later on, will express the very fact that the technical assistance notice which was sent by the Penglia's government officials does not stand legal in point of law, your lordship. Firstly, your lordship, the counsel on behalf of defendant humbly submits before the Honorable Court that the said encryption law is in contravention with the right to privacy guaranteed under the Article 21 of the Constitution of Penglia. Your lordship, the counsel, the focal point of my argument would revolve around the fact that the notification which was released by the government to link the banking data to a data repository called as CASN. The very fact of linking this private data, it poses an imminent threat to the sensitive data and endangers the personal data of all the citizens. Your Lordship, notwithstanding with anything contained under Article 32, it merely states that the company has to implement security reason and follow due diligence, but does not follow a procedure to establish that it makes encryption mandatory. Your Lordship, furtherance to this claim, the Penguin law on encryption undermines the very cyber security and human rights, including the right to privacy, providing a leeway for companies to build a backdoor and hand over user data without encryption and following mere safeguarding guidelines set by GDPR. Your Lordship,
I have a question.
Yes.
Please be very specific. On what grounds or on what basis are you contending that Pengelia law is against or violative of the right to privacy?
Your Lordship, Penglia's law, first of all, to test whether there must be a reasonable legislation intent behind a procedure being followed, as it was put forward by the judgment in the Puttaswamy that there must be a reasonable procedure followed by a law. Your Lordship, in this case, the Penglia encryption does not meet the requirements set by the Puttaswamy judgment. In furtherance of this claim, the counsel would like to elaborate about this in the further submissions, Your Lordship.
So, counsel, are you trying to tell the court that your argument is based on only one precedent of the Supreme Court?
No, Your Lordship. We have various other precedents, such as in case of Maneka Gandhi, which came out with a triple test stating that there must be a reasonable and fair justifiable nexus behind legislation, and furtherance so that a law should be not in violation with Article 19 and 14 as they are very intrinsic part of the Constitution.
What is the nexus there? Actually, that's a very good point, but what's the nexus?
Your Lordship, the very point here is that the encrypted data which is being stored in a repository of the government, it poses an imminent threat as the data is more vulnerable to various cyber attacks. The data which contains the private and sensitive data of the citizens of Penglia, Your Lordship. This nullifies the very point of having a sensitive data being stored there, Your Lordship. So there is a reasonable nexus to understand from this point that the privacy is being violated by the information getting leaked or getting hacked by some other state actors, Your Lordship.
And is there a decision of the Supreme Court of India that could be of assistance in determining the constitutional, that besides Puttaswamy, of course, but it's not like a general test about constitutional breaches?
Your Lordship, the counsel would like to draw your attention to the case of T. Sarita versus T. Venkataya Subaya. The court held that the right to privacy is a fundamental right. And also, Your Lordship, in the case of Puttaswamy judgment itself, and in the case of ADM Jabalpur versus Shivakant Shuklan Constitution Bench, it arrived at a majority that the Article 21 is the sole repository of all right to life and personal liberty, and when suspended, takes away those rights altogether. Your Lordship, this is where we will underpin our argument based on this, Your Lordship.
Please move on. Thank you very much.
Much obliged. Your Lordship, the counsel humbly submits before the Honorable Court that the right to privacy is a fundamental right, and said right has been infringed upon in this instant case. Your Lordship, it is therefore established beyond doubt that there's a legal right of privacy. Every individual has the right to privacy as a part of his overall right to live with dignity without being interfered by any excise of any fundamental right or unreasonable justification.
In all fairness to your colleague who was requested to slow down, I will respectfully ask you, and I'm sure my colleagues have that in mind. I don't want to read their minds. I don't have this power. I have many powers, but not this one. But I will ask you to slow down your pace a little bit. Thank you.
Much obliged. Your Lordship, similarly, in this instant case, the law passed by the government is violative of Article 21, as it infringes the right to privacy by providing various investigation authority power to gain access to this critical data, which is being stored in the repository of Penglia's government. Your Lordship, it is further submitted that the law established by the Penglia's government is not in consonance with the procedure established by law, Your Lordship. In the case of Maneka Gandhi versus Union of India, the court had adopted a threefold test. Your Lordship, it determines whether this threefold test is in contravention to the legislation which is being backed up by the Penglia's government. Further to this, Your Lordship, the procedure must satisfy the essentials of Article 14 and 19 respectively. It should be just and reasonable and fair. Your Lordship, with respect to Article 14 and 19, which talks about right to expression of freedom, Your Lordship, this main intent of legislation is not being backed up by the government itself. Your Lordship, there is a probability that this legislation can be used as a wider range for various other purposes like mass surveillance, Your Lordship. It is submitted that the challenge and procedure established by law is not in consonance with the either of the conditions mentioned in the aforementioned judgment, Your Lordship. Your Lordship, furtherance to this, we would like to submit the court about the legality of technical assistance notice. Your Lordship, it is humbly submitted before this honorable court that the technical assistance notice, which was being served by the by the Penglia's government agencies, the very nature of the evidence is self-incriminatory nature, Your Lordship. The council humbly submits before the honorable court that the Penglia law on encryption grants power to issue technical assistance notice to the companies operating in Penglia and helps the government to decrypt personal data stored in citizen of Penglia. Your Lordship, this undermines the very basic purpose of having a fundamental right in the first place, Your Lordship. Your Lordship, it is essentially giving access to the companies to have a decryption method, which makes it more susceptible to various other crime activities or cyber crimes happening in this first place, Your Lordship. To furtherance of this, Your Lordship, yes.
Do you have any idea about what is physical security policy, and can you relate it to your case?
Your Lordship, the council would like to ask to repeat the question, Your Lordship.
What is physical security policy? Is it in any way related to encryption laws? And can you relate it to your judgment, to your written submissions?
Your Lordship, the council would like to get back to you on this, Your Lordship, in the furtherance of the claims in the further arguments, Your Lordship.
No need to get back to us. You can plead ignorance if you don't know about physical security policy.
The council seeks ignorance, Your Lordship.
All right, continue.
Your Lordship, in the very first place, the defense counsel would like to submit is that encryption mandates the company to comply with technical assistance notice, and if the companies refuse to do so, they could face financial penalties as well as imprisonment, Your Lordship. The defendant was pestered to comply with technical assistance notice and grant access to the personal critical information and data. Your Lordship, the defendant is being forced to comply with this aforementioned provision and has led to be, and the nature of evidence itself is self-incriminatory in nature, Your Lordship. Your Lordship, it is pertinent to note that the Penglia law encryption mandates the companies to comply with it, and therefore the council humbly submits before the honorable court that the Penglia law on encryption is infringing the right to privacy under Article 21, as infringement of fundamental right should be held unconstitutional. Moreover, in the light of arguments presented, the technical assistance notice shall be legal and won't be admissible in the present case, Your Lordship.
Well, how do you establish, generally speaking, a constitutional breach as per a decision, not to say famous decision, of the Supreme Court of India?
Your Lordship, we would like to refer to the case of Govind versus State of Madhya Pradesh. It was held that the right to privacy was not expressly guaranteed in the constitution, but it is implied in the fundamental rights.
No, I understand that, counsel. Maybe I will rephrase my question. I may not have come across as clear as I wanted to be. What is the legal test crafted by the Supreme Court of India to determine if about the and I'm not necessarily talking about breaches in general, but about it was my question was more general. So basically, can you, and I will refer you to the decision that was cited by the applicant, the decision, and this is a general principle. So it's not to say that they're right or wrong, the applicant, but the test of the Supreme Court of India in the decision Kerala that you know, I'm sure, but can you tell the court how the legal test that the Supreme Court of India crafted, set out, and that decision applies to the case at bar, and how do you apply it if it is applicable?
Your Lordship, so in this instant case, the procedure must satisfy the essentials of Article 14 and 19, which was set out by Supreme Court in the case of Puttaswamy judgment. Further, and so that the justification of the law procedure being implemented by the Penglia's government must be reasonable, just, and fair, Your Lordship. In furtherance to this, the articles, any fundamental rights should not be infringed upon to this, Your Lordship.
Okay, thank you. But isn't the thing is, isn't it the test a bit more sophisticated than just the reasonability of the legislative measures taken? My understanding is that there's several prongs to the test and not only a one prong that applies. There are several steps that the Supreme Court of India identified, and I understand you addressed the reasonability of it, but there's still some other steps as far as I understand it. So if there are, which I believe there are, but if I'm wrong, correct the court, it's fine. But can you apply these steps according to your views? Of course, the views of your party and of your submission, not, of course, your personal views.
Your Lordship, there has to be a legality before any legislation being passed, Your Lordship, and there has to be a test of proportionality being set here, Your Lordship. Your Lordship, we would like to further explain a bit about the encryption law as to define whether this legislation has an act of proportionality altogether, Your Lordship. Your Lordship, this act encourages mass surveillance, Your Lordship. The act also seeks to discourage end-to-end encryption by design, blocks access to any parties. Your Lordship, the very systematic fact that the entire system is becoming vulnerable, it makes it more susceptible to various crime or other cyber breach attacks. Your Lordship, this basically fails to address the point which was set out by Supreme Court in test of proportionality, Your Lordship.
Thank you. You can go back to your submissions.
Much obliged, Your Lordship.
Counsel, pardon me, but I would like to come back to a question I posed to your counsel, and it is
Your Lordship.
the utmost importance, in fact. And I would like to give you a second chance to explain this. But throughout your memorials, several times you forward a contention that the IP of the computers from which the cyber attacks were traced could not be relied as truthful because, in fact, you claim there was the use of some IP spoofing technique, and you also claim there was the DDoD, distributed denial of service attack. But neither of these contentions seem to be based on fact. So I would like to ask you to direct me to the specific part of the paragraphs of the case where you draw this contention from, lest it be considered absolutely unwarranted.
Your Lordship, if the counsel would like to draw attention to the paragraph 14 of the factual matrix. Apologies, paragraph 14 of the factual matrix. It clearly tells that Vault of Company and Co. had been alleged of data breach, Your Lordship. There's no conclusive proof as to a fact to ascertain that the company was being held liable, because the sole reason here being the prosecution heavily relied on the fact that the IP addresses were being traced back, Your Lordship. And Lordship, in the furtherance of the question raised by the Lordship, we would like to prove in our fourth issue that tracking down of an IP address should not be the very sole base of any conviction, Your Lordship. The counsel would like to elaborate on this in the fourth issue, Your Lordship. Thank you. Much obliged. Counsel seeks permission to move to the fourth issue, Your Lordship. Much obliged. Your Lordship, the fourth issue is whether the Vault of Company and its officials be prosecuted for conspiring for the breach and relevant provisions of Penglia's Penal Code. Your Lordship, it is submitted that they are not liable to be prosecuted in section 107 of the Penglia's Penal Code that provides for abatement by conspiracy, Your Lordship. The same shall be established subsequently by proving that the company never had any intention or never had any agreement between the parties to conspire a breach against this. The prosecution has failed to prove beyond a reasonable doubt that there was a conspiracy being hatched against the defendant. Your Lordship, the very definition of conspiracy in 128 tells that an illegal act or provided that no agreement except an agreement to commit an offense shall amount to criminal conspiracy unless a act besides the agreement is done by one or more parties. Your Lordship, the very argument which is primarily being based on the prosecution stating that there were more than 3 IP addresses. But Your Lordship, an IP address can be accessed by any state actors, Your Lordship. This does not give a conclusive proof as to whether to held that the IP addresses were coming from the Vault of Co, Your Lordship. And also furtherance to this claim, Your Lordship, there has to be more than 3 parties involved. The prosecution has heavily failed to address the point beyond reasonable doubt that there was more than 3 parties involved, Your Lordship. Your Lordship, on the pursuance of the definition of yes, Your
So
Lordship.
let me interrupt you again. I would like to dispute your claim that the IP tracking mechanism is
yes, Your Lordship.
You would have to provide some credible evidence that IP spoofing was used, or that some element of doubt was introduced, because the IP tracing the IP is actually the most fundamental and reliable
Your Lordship, yes,
method there is. So again, you would have to claim and substantiate a claim of some IP spoofing that would be would have
much obliged. Much obliged, Your Lordship. The result of the IP address tracking down the digital footprints using IP address cannot be reliable proof because of ever existing. It could be seen by any other parties itself. Unless the prosecution proves otherwise beyond a reasonable doubt, then we can understand to a very ascertaining fact that the IP addresses were being traced back. Your Lordship, as the question was being asked that whether the IP addresses should be justifiable in our case, Your Lordship, we would like to prove in one sub issue that tracing down of an IP address should not be the very sole base of conviction. Your Lordship, it is humbly submitted in the case of Elfman LLC vs. Eric Coast, while granting motion to dismiss opined the claim for facially plausible when the plaintiff pleads the factual content and allow the court to draw reasonable inference when the defendant is liable for misconduct allegedly. Plausibility requires pleading facts as opposed to contrary allegations. Your Lordship, in this case, it clearly finds that the IP address does not necessarily mean that the owner of IP address was the infringer. Identifying the IP subscriber solves any part of the puzzle, Your Lordship. Therefore, an IP address cannot be the sole basis of conviction. IP address can be spoofed easily due to structural anonymity of the internet, as there is no provision for cryptographic authentication, Your Lordship. If that question answers the your Honorable Lordship. Your Lordship, furtherance to the question which was posed by the bench, Your Lordship, the IP address can be spoofed easily as there is no systematic cryptography authentication of the internet protocol which is being followed here. Therefore, it is humbly submitted that no liability arises on the account of Waldorf being an intermediary and prosecutor under Section 17 of the Information Technology Act, Your Lordship. Your Lordship, we would like to further.
Well, yes. Does the fact that IP spoofing is available to unexperienced hackers, does that already completely, does that completely qualify IP tracing as a method? Because otherwise we would never rely on IP tracing if there's the possibility of IP spoofing without the necessity of proving it.
Your Lordship, there might be a possibility of such a nature since these IP addresses can be tracked down, since they were in the factual matrix itself, it was given that these the IP addresses were tracked down to 3 different units. Your Lordship, there might be a possibility in this case that the IP addresses were used by other state actors to commit this breach. So Your Lordship would like to humbly submit that the IP addresses are structurally anonymous in the nature. We cannot trace back as to what is happening through IP addresses. There might be a possibility that this IP addresses were being used by some other state actors who are responsible for this criminal breach attack, Your Lordship. Much obliged. If the Lordship is satisfied with the answer, the Council would like to proceed with the final sub-issue, Your Lordship.
Yes. Please.
Your Lordship, it is humbly submitted that in furtherance of the above mentioned, the defendant, by the virtue of being an intermediary, was unaware of its service being used for an unlawful purpose, Your Lordship, for launching the cyber attack to cause the data breach. Hence, due to absence of knowledge on part of defendant, the offense of the conspiracy cannot be proved, Your Lordship. Your Lordship, it is humbly submitted in the light of aforementioned judgments, it can be authoritatively concluded that there is no establishment of conspiracy proved by the prosecution, that there is no mere agreement in the first place, Your Lordship. There is no parties more than 2 involved from the defendant, and the defendant had no knowledge or intention or a common design to conduct this sort of cyber attack, Your Lordship. Hence, Your Lordship, we humbly submit in front of the Honorable Court that the defendant is not liable to be prosecuted for conspiracy under Section 120A of Penglia's Penal Code. It is put forward that they cannot be held liable for abetment by conspiracy under Section 107. Therefore, Your Lordship, the Council humbly submits in light of the established points. World of
But
company.
you basically bring back the issue of conspiracy, which was addressed by your colleagues. So I understand that if you bring it back, it's because you have an answer more specific to the issue of the existence or non-existence of an agreement. If not, if you cannot enlighten the court with further knowledge, I will simply ask you to move on to your next submission, because I don't want to commit my esteemed colleagues to this, but I do not at this point consider the answers provided to this serious concern of the existence of an agreement or not to be fully, not saying that they were not partially satisfactory, but I do not consider them as a judge here, not as representing the entire court, as being satisfactory. If you have further answer to provide to the court specifically addressed, I'm happy to hear it. I'm sure my esteemed colleagues will be too. Otherwise, move on to your next submission.
Your Lordship, much obliged, Your Lordship. Your Lordship, the defense would like to rely on a case here, Your Lordship. In the case of Ramachandar versus State of Rajasthan, it was held
I'm sorry to interrupt. Impolitely, it was not meant to be disrespectful, but I see that your time is up. I just ask you a question, so I'm faulty here. I will ask you to answer in less than 30 seconds to my questions, because I'm the one who asked you a question at the very end when your time was up. And then after this 30 seconds, I will ask you to summarize your submissions, and then please give away the podium or virtual podium.
Much obliged, Your Lordship. Your Lordship, in this case, it was held that a few bits here and few bits there on which prosecution relies cannot be held adequate for connecting the accused within the crime of criminal conspiracy. It has shown all the means adopted and illegal acts done were in furtherance of the object of conspiracy has. Your Lordship, there is no conclusive proof, and there is no conclusive proof proved by the prosecution that there were agreement between the parties of defendant, Your Lordship. This justifies the very fact that the prosecution has failed to justify that the company were liable beyond a reasonable doubt, Your Lordship. Your Lordship, we would like to further submit that the company is not liable under section of 107 and 120, Your Lordship. With the permission of the bench, the council would like to proceed with the prayer, Your Lordship.
Just summarize, yes, prayers, and that would be it, I think.
Yes, agreed.
Yes, Your Lordship, the council would like to add a fact here, is that the very essence of conspiracy here is an agreement, Your Lordship. The agreement being absent here, whether it is in written and oral form, renders the very fact of the company being liable under this section, Your Lordship. And furtherance to this, the IP addresses which were alleged by the prosecution were being used as IP spoofing, Your Lordship. And thirdly, the encryption law which was in contention, Your Lordship, it violates the very fact, the very fundamental right of the Constitution, Your Lordship, that is Article 21 of the Constitution, Your Lordship. The council seeks permission to move to the prayer, Your Lordship.
Thank you very much. Thank you very much, Council. We will now move on to submissions for on rebuttal, if I may call the applicants. Well, not call, but ask the applicant to take the virtual podium to make their submission on rebuttal.
Much obliged, Your Lordship. Your Lordship, firstly, the respondents have made no reference as to the liabilities leveled against them under the Penglia Cybersecurity Act, the Penglia Liabilities of Misuse of Computers Act, and the General Data Protection Regulations in their written submissions at all. Secondly, Your Lordship, within the provisions of Section 79 of the IT Act, upon the notice for technical assistance being issued to the respondents, they were duty bound to comply, failing to which they would be absolutely liable within the meaning of Section 79 subclause 3 subclause B. Thirdly, Your Lordship, referring to the arguments advanced by my worthy contemporaries appearing for the respondents, there was the rational nexus in issuing the notice for seeking technical assistance was qualified under the circumstance where then there was a threat to national security. So, Your Lordship, in such circumstances, referring to the arguments advanced by my worthy colleagues appearing for the respondents, the Penguilian encryption law is duly qualified to be constitutional. And lastly, Your Lordship, within the ambit of the moot proposition, there is no mention of IP spoofing and or a digital denial of service attack. That is a clear extrapolation of the factual matrix and is beyond the ambit of the moot proposition. And with that, the council concludes, the council appearing on behalf of the applicants concludes the rebuttals, Your Lordships.
Thank you very much, counsel. We will now move on to submissions on rebuttal. If I may ask the counsel from the respondent to take the podium, virtual podium, so to speak.
Your Lordship, the prosecution had mentioned that there isn't a reasonable nexus between the legislation which was being enacted by the Penglia's encryption law, Your Lordship. Yeah, the arguments which were submitted by the defendants clearly reasserted the fact that it fails the test of proportionality, Your Lordship, in the first place, that this system is itself in nature as a mass surveillance, Your Lordship. Your Lordship, such a measure in draconian nature, because it would allow eavesdropping capabilities to the government, Your Lordship, it requires the development of tool of its customers indulging in any sort of nature, Your Lordship. So this, in fact, would render the Constitution of 21 of Penglia's, Your Lordship. In furtherance of the claim made by the prosecution that it was not in the ambit of being the IP address spoofing, Your Lordship. Your Lordship, the prosecution arguments were heavily residing on the fact that these IP addresses were being traced back to the Waldorf and Company. Your Lordship, the council would like to draw your attention to the point number 14, that the very first sentence of the factual matrix clearly states that the Waldorf Company Limited had been alleged of a data breach, Your Lordship. The onus lies on the prosecution to prove that the IP addresses were being concurrently run by the defense company. Your Lordship, we, in this furtherance of the claim, we substantiated a fact that there might be a possibility of other cyber attacks happening through other IP addresses. Your Lordship, the very fact being here is that the encryption law itself has a whole vulnerability itself, Your Lordship. Furtherance to this, Your Lordship, when you have a key access given to an encrypted technology, Your Lordship, there might be a reasonable attack coming from any other cyber attack or any other state actors. Your Lordship, the council would like to draw to your notice in the case of in the case of a black door concept which was widely contested, Your Lordship, that is the NSA losing its stockpile of Windows 0 Day, Your Lordship. Here there was a black door concept which happened altogether where NSA allegedly made a public statement that their 80% of data is more susceptible to other companies in leakage of data, Your Lordship. It is pretty evident here, Your Lordship, that this data is more vulnerable to cyber attacks, Your Lordship.
I'm sorry to interrupt you in your rebuttal, but in this, I believe is partially to your benefit. Indeed, one can say because IP spoofing is so common that sometimes IPs that have no relationship at all to the cyber attackers, to the cyber criminals, get involved and could be unfairly traced as the origin of the cyber attack. However, in interpreting such situations, the context is relevant. And in this case, the defendant did choose not to comply with the request by Penglia's authorities to offer data. Instead, it partially deleted all of them in a potential jest of bad faith. So does that not render the IP tracing truthful and believable, credible?
Indeed, Your Lordship. Firstly, Lordship, we would like to clarify on the very specific point that the assistance notice which is being asked by the prosecution, that the very primary based evidence is being self-incriminatory in nature, Your Lordship. That is in violation of basic constitution right, that is under Article 20, Section 3, Your Lordship. And based on that, Your Lordship, the very fact that the companies are being asked to decrypt their own technology makes it more susceptible, Your Lordship. There might be various other companies or various other state actors who would take an interest in this and would definitely provide any sort of cyber attack breach happening, Your Lordship. So the very system here itself is not that complex because there are loopholes in the very establishment of an encryption, Your Lordship. So this basically relies on the prosecution that their system itself has a lot of loopholes, which makes it more susceptible to other companies, and also it provides a backdoor or leeway for other companies to access this personal data, Your Lordship. If the question is answered, Your Lordship.
Well, I will not allow. I will not. I'm sorry. I don't want to interfere. But if my esteemed colleague doesn't consider his question to be answered, he will ask you to clarify your answer. Otherwise,
Indeed,
I will ask you to not ask the court. Thank you.
Indeed, Your Lordship. The council seeks permission to rely on various other facts of this case just to prove this with the permission of the bench, Your Lordship. Indeed, yes. Your Lordship. Lordship, the council would like to draw the court's attention as to how a backdoor concept works, Your Lordship. Backdoor in computing is a method of bypassing the normal method of authentication, Your Lordship. Backdoors are usually inserted into programs or algorithms before it is distributed widely, Your Lordship. They are often hidden in part of a design of a program or an algorithm, Your Lordship. The cryptography specifically ensures that there is a backdoor which has an intruder access, Your Lordship. So here, Your Lordship, there might be a skeleton access key card given to the company which holds a key to various data which is being sent in the stockpile. There might be a possibility that other companies would access this because the very susceptible crimes which happen might use IP spoofing method to trace back to this company and breach this, Your Lordship. So the very concept of backdooring itself helps that there is a huge loophole in the company itself, Your Lordship, because when there's a backdoor concept, there are various other companies who definitely try to exploit the situation in order to commit a cyber breach, Your Lordship.
Have you finished your rebuttal? How are we in terms of time?
Your Lordship.
Thank you.
Thank you very much. Thank you very much to my esteemed colleague to have asked this quite relevant question at this point. So I understand that while the judges will deliberate, I understand that we will be given the occasion to, of course, deliberate in chambers together, not in public, so you can see us deliberating. May I ask if we are going to be brought to a different virtual courtroom to do that?
Yes.
Excellent. So that's good. So thank you very much to all participants to the finals. Final round. I will ask the grand finale. I will ask you to hold on and wait for the judges to get back to you with feedback, and it may take some time. That was in my opinion, I don't want to say anything substantial here, not substantive, but I assume it's a tough call to make. So I will ask you to hold on and wait for us, even though it may take some time for the judges to deliberate, especially that we have 5 knowledgeable, skilled, experienced, and highly qualified judges on this bench. So I would like you to wait for us to be back. So I will ask the bailiff, respectfully said, to bring the judges back to, not back, but bring the judges to the deliberation room. Thank you.
Judges, you can join the breakout room. teams, I would ask you to wait till the time judges decides the final results.
TC20 and TC22. Everyone please switch on the cameras. Teams, would you like to give the reviews for the today's session?
Yeah, can I give a feedback?
Yeah, sure.
Yeah, so apparently I would say that this is the only bench which grilled us a lot on technical aspect of the proposition. In my various rounds, we generally dealt with other sections such as 20, I mean, the other penal laws which were in contention. So I would say that I've learned much here comparatively to other benches where I pleaded, because where the questions which were asked here were more pertinent to the proposition as it deals much with cyber law here. So overall, I would say that this was a very informative session on cyber aspect as it was put forward by the honorable judges. So I would say that we did learn that there were various parts where we could have highlighted our points as well. So yeah, it was a good session overall. Thank you.
Thank you. Any other speakers?
I'm sorry, I missed the question. Was it regarding the feedback of this?
Yes, it was regarding the feedback.
Okay, yeah, of course. I think the prop was quite interesting, and you, as you have been mentioning in the introductions, that it is a mixture of international plus Indian laws. So that was also interesting to deal with. I was very interested in dealing with the constitutional aspect of cyber law, so I got to get some experience with that. Yeah, the overall experience was great. I enjoyed the judges panel as well for the most part. So yeah.
Thank you.
So I will ask all participants to turn their camera back on. And of course, mute themselves. Let me check if we have everybody. I just see the
TC,
yes,
do you have the answer too?
I'm sorry, I didn't hear you. What did you say? Sorry.
Sir, I was asking, yeah, I was asking TC20 Council 2 to switch on their video. Yeah, it is done.
Sure. So welcome back. Thank you very much, everybody, for waiting and be patient. I will now move on to feedback. I will ask my esteemed colleague to start. We discussed it, so I will be the last person to provide feedback. Thank you very much.
Hi again, everyone. I'll briefly introduce myself again and then swiftly move on to the feedback. As earlier stated, I'm an information security officer at the Bank of Georgia, which is one of the commercial banks in Georgia. And at the same time, I'm an attorney at law in Georgia. I have previous experience in providing legal services as part of a consulting company. At the time, I'm also an investor, a contributor to investment claims by Oxford University Press and a junior fellow at GRN think tank program in alternative dispute resolution. And throughout my career, I have been actively involved in moot court competitions, and I have also established Tbilisi State University Moot Court Society, which is the first of its kind in Georgia. So moot courts are quite dear to my heart, and I'm always happy to participate in any way I can. So with that said, I would like to, first of all, thank the organizers for giving me this opportunity and congratulate you on such performance, especially in such short amount of time of preparation. I'll try to be as brief as possible with the feedback. It won't be individual. It's considering that more or less it applies to all the participants. I will focus on time management, first of all. It is very important. It doesn't matter in which competition it is or whether it is a real life case. Time management is very important. And there were instances where it seemed that the participants didn't focus on their own time, and that is definitely a flaw on its own. But it's another issue when the bench is generous enough to give you an additional time and you sort of put it to a different kind of use and you proceed with submission rather than summarizing. And I just want you to know that it's important that you show respect for the judges by following their order and complying with their request that you summarize, let's say in 30 seconds, you summarize in 1 minute, and so on and so forth. And this is something that will be useful for you in the following competitions to come. Another thing is delivery. I also indicated during one of my questions that it doesn't really matter as much as you might think at this time. It doesn't matter how much you speak if it is not reaching the addressee. We have to be able to understand what you're saying, and obviously we have to be able to listen to you and follow your line of argumentation. So I would like you to keep this in mind. In general, I think this is an important skill, life skill in any sort of relationship, you know. So be mindful of who is listening to you, and be mindful of your delivery, so that it's not too quick, it's not too slow, it's not filled with too complex of words, and so on and so forth. These are sort of the two things that I, during my mooting experience, learned, and this is something that I want you to know so that you make use of it in your future endeavors. Thank you.
So if the president allows me, then I would like to give my suggestions and comments.
Please.
Yeah. So According to IST, a very good afternoon to all of you. I am Dr. Bhavna Batra. I am the faculty convener of the E-Moot Court Society in my law school for last 10 years. So almost completed a decade in the mooting. Moot courts are really very close to me. I have come across in my last 10 years academic odyssey, a lot of students who take part in the moot and who come to us in the moot. So we take amity to the world and bring the world to amity in the moot court competitions. Also, I have had the privilege of being the Deputy National Administrator for JESA in 2018, 19, 20. In 2021, I was the National Administrator from India. So this is something which I wanted to tell you about myself. Students taking part in a moot court competition is not easy, quote unquote. Along with your academics, this is a platform which is a co-curricular activity in a law school, and it is trying to hone your oral advocacy, your rhetoric skills, your research skills, as well as the team spirit. And I personally know it is not easy to make a team. At times when you are a 3-member team, you have a lot of conflicts in the team itself. And in the moot court, you must be able to overcome the conflicts. I can see the smiles coming on face of TC20, even TC20 Council 1, because they know ma'am has touched the real chord. Am I right? Yes. So that's the spirit behind the moot court. Students, please remember both TC22 and TC20, you are privileged enough to reach the finales. So that is a blessing for both of you. What I felt in the competition was technical glitches. We did not even consider that. My president and all my colleagues were very, very polite and kind. We did not deducted any marks, quote unquote, for technical glitches. But yes, teamwork is important. So when you are a 3-member team, we count on the teamwork because you know in team, everyone together achieves more. So if you are getting what I'm trying to say, team really works and it matters in a team like competition, moot court competition. Secondly, I have an observation. When the judges are asking you students, you know, we have to mark you on poise, demeanor, code etiquettes, time management, workflow, knowledge of facts, knowledge of law, your ingenuity, everything. So when it comes to a virtual platform, when we are asking you questions, we know you know a lot. So it's not that we want to know what you know. We want to know what we are asking you. So please keep that in mind. In this competition, I was getting an impression that you are letting us know what you know and deviating from what we are asking you. So that was my observation. And I want to summarize by making you realize the importance of one important quote, which I personally follow in my life. And I quote, "In life, winning and losing will happen. What is never acceptable is quitting." All right, so please remember, winners and losers will be there. What is more important that winning and losing is you never quit. Once you are a winner, you may be a loser because this too shall pass. And I would sum up my argument by saying that journey is more acceptable than the outcome. So the journey which you all have traveled is very, very important. I know that journey is going to be logged in your hearts and in your memories forever. And I thank all the esteemed judges and the organizers, Paki, Megha, and I don't know your name. No, you are the third one.
Ma'am, Akash.
Akash, yes. So we've been getting mails through Akash. The 3-member team is a very coherent team. They have really shown and made us proud by hosting such a virtual competition. And I also thank 3 of you for getting me connected to the co-panelists in the bench. All people are wonderful. And now I'm going to pick these people and make future collaborations also with your permission. So thank you so much and all the best. And I now hand over the podium to Mr. Pedro. Thank you.
Hi, everyone. My name is Pedro Borges. I'm a law graduate from Rio de Janeiro, Brazil. And I'll soon be going for my LLM in Europe later this year. I focus in public international law and cyberspace and technology, etc. During law school, I co-founded a public international law litigation society with some friends and we took our university for the first time ever to the JASIP. It's not that our university was new or anything, it was an old university, but apparently no teams from neither our university or from our city or our state in the federation had been to the JASIP before, which was crazy for us because Brazil had actually a long-standing tradition. So we started this in 2017. I wanted to go for a career in public international law. And I also since had an interest in law and technology, cyberspace. Well, since then, we consolidated our society at university, became a greater thing. We took part in other moot courts internationally, and I dug deeper into law and technology as well. And at the end of my 5-year degree course, I wrote an LLB thesis on state responsibility for cyber operations. And in that thesis, I actually got really picky with IP spoofing, by the way. Well, yeah, so it's just always, I know how hard it is to go for a moot court competition. And for the first time I did it, we had little support. Even our professors didn't really know what to do about it. We had professors who had experience with different moot courts, even moot courts in public international law, but didn't know what the JASIP was really about. And if you have an opportunity to go for the JASIP, do it. But most of the judges here are JASIPers, so you got a taste of how hard it is. And it's all about time constraint mainly. You had this experience. It's amazing what you did with so few days actually, and you just came here into the lion's den. It's a den of beasts that gotta tear you up, and you just came here and you stood your ground anyway. That's important. So congratulations just for taking part in it. No matter how hard or frustrating it can be, it certainly has made an impact into your future career and your legal skills. So with that in mind, I will leave as my only feedback this. It's very important to attain to the facts. The hypothetical case is meant to be a self-contained story. You can't add over inferences. You risk making things up in a hypothetical case in which you have limited options to conduct evidence searching. It's not a real life. So, and then this is a very serious thing in actually courtrooms. If you just go out of your purview with regards to inferences from the fact, you may get smashed, and certainly you will get smashed in most moot court competitions. So this is very important to control, even if there is an important point to be made with regards to the factual reality. It's important not to stray from the actual hypothetical case, not to make things up, even if the case is designed in a way which is almost impossible to circumvent in your arguments. And it may be like that in most cases, like this one broken paragraph that you can't get around, and it's desperate. It can be like that, but I also think it's gonna be like that most of the time in real life, more than in the hypothetical case. So yeah, and judges know how hard a specific part of the case is going to be to a specific party. So the important thing is just to find an angle through which you can actually argue and know your limits. That's it. But time constraints. It's a Herculean task to take part in a moot court. And speaking of which, it's 6:20 a.m. here in my city, Rio de Janeiro, right now. So I've been up since 3:30. So I know about time constraints. And by the way, Sebastien Lafrance is also up since, I don't know, yeah, really late. It's
2 a.m. and it's 5:20 here.
Yeah, so time constraints, everyone knows it, even judges. But congratulations, everyone.
Yeah, hello. I am Rishabh. I am working as an information security professional and a data privacy architect. in my career experience, I have worked with a lot of contracts negotiation. I have seen many of the vendors, partners who deal and come across with a conflict in terms of cyber security measures been put across in the contracts, and how or what measures we have to comply with when we do an yearly review to ensure that the KPI measures are being met. There are a lot of constraints. There are a lot of challenges in terms of where the cyber law is progressing, and we do see that mostly due to the enforcement of GDPR. Worldwide, we have seen a lot of improvement in terms of data privacy be coming into place, and this sort of boot competitions and cyber security, specifically targeting the privacy world, is helping the customers to secure their data, right? And as an individual, to help ensure that we know and enact to our privacy of data. So very well performed by all the applicants and respondents, well aware of the facts. Yes, there are gaps in terms of where the cyber law stands, where all the how do we come onto a common platforms in order to decide, where the certain clauses, certain restrictions been put across to identify the intermediaries, the sources, the attackers. But yes, it is a difficult decision to make. But congratulations all who have been as a participants to this competition. And I thank to give me the provision to be a part of this panel. I really enjoyed the awareness and the facts being shared, and to be a panel member. To give as a key advantage to be taken as part of this session was really well-known facts, well-known research cases, clauses been referred from various acts, certain improvements that I see in terms of engaging with the time being taken by the applicants to address the jury panel's queries, and the respondents to be well aware of how to manage time in the next forthcoming sessions, and to well aware of the facts that how judges are going to question. And best of luck with your near future. That's it. Thank you from my side.
So hello, everybody. I'm Sebastien Lafrance. I had the honor to preside this panel of great and amazing and skilled and experienced and knowledgeable judges. So I would like to thank them first, seriously and sincerely. I would also like to thank the organizers of this moot court. That was quite exciting. So thank you very much for the organization. It was awesome. Who am I? Briefly, I'm a prosecutor, Crown Counsel, as it was told to you earlier, since several years. I now specialize in competition law, criminal cases, but I'm more than that. I'm basically, and something else I want to point out first, before I forget that, because that's very important. My esteemed colleague Pedro, call him by his first name, and I'm the only one who's allowed to do that, and my judges can do that as well. My esteemed colleagues can do that, because I consider Pedro as a very good friend. We also co-write something, or will co-write very soon something together. So it's something that Pedro pointed out that matters. He made fun about it somehow, but there's a point he made there that I just want to emphasize. About the facts, of course, do not make up facts, but I think Pedro nailed the point here. But about the time it is for us. He said it's 6:20 a.m. in Brazil, and here in Toronto, Canada, it's 5:20 a.m. So basically, we woke up in the middle of the night for this. Why? There are two possible answers to this. The first is we are totally crazy. Maybe. I'm not going to answer this. Or second, more plausible answer is we are passionate about moot courts, as all judges on this panel. But this is something else I would like to emphasize before introducing myself a bit further. But you have judges who come from every single part of the world, like from various continents, various time zones, who are passionate about moot courts and who really wanted to be here to judge you today. And who are all, including myself, very honored to have judged this this final round. So I wanted to say this, it matters to me. So to go back to briefly introducing myself, I'm very attached to India. I published in various countries, in 7 countries so far. I lecture a lot worldwide in 20 countries so far. I'm a polyglot. I speak various languages, more than 15 fluently. But I'm very attached to India. So that's something I want to say that matters to me. And what else? I was a professor of law for a few years, 3 years. And then after that, I became a prosecutor after clerking in the Supreme Court of Canada and for the Chief Justice of the Court of Appeal. So I'm basically working nonstop. So I'm not going to tell you my entire resume. But basically working 20 hours a day, 7 days a week, because I love it. That's it. I love the law. So this is what moot courts is all about. It's about the love of the law. But loving the law also means loving what it implies. And moot court is the best, in my opinion, the best occasion to see and test yourself and see your skills, your qualities, but also your flaws and things that need to be improved. So I hope you took very good note of what my esteemed colleagues told you, because it matters a lot. Every single judge's comment were very on point, crisp, and totally relevant to all of you. We decided to not provide particular comments because we basically consider that if the hat fits, you just wear it. But most of these comments apply to all of you, to everybody. So personally, I would like to emphasize one point. When the judges address you and ask you something, please be responsive. I endorse totally what my colleagues mentioned, but I'm not going to repeat their comments here. But be responsive. Please listen to the question. And as Rish pointed out, when the judge has a query about something, it's your time to connect it and to show your knowledge, but also please connect the law with the facts, because sometimes you may know a lot about the law, you may know a lot about the facts, but there may be problems sometimes to connect the one with the other. And this is what makes a good argument, because the famous proverbial saying is, okay, when the law is not on your side, please hammer the facts. When the facts is not on your side, please hammer the law. But in the moot court, you have to hammer both. And you have to master and grasp and make the judge understand your point on both sides. This is also what makes it difficult. So do not recite the law. So you need to be specific. Even though not all judges on this panel are Indian, we all of us are aware of, at the very least, the decisions that were included in the memorials and in your submissions. Personally, since I'm very attached to India, I'm also somewhat close to understanding and knowing the applicable laws of India. So that's something you have to keep in mind. And this case was not easy. Sorry about that. This case was not easy because it was, and this is why I ask you this question: what areas of the law are we talking about? It's because basically this case is not limited very narrowly to criminal law or constitutional law or IT law, to a certain extent, like it is its own beast. But you have to basically go from one to another. So that's something you want to be, and this is why this connection between the law and the facts is so important, because clarity must not only comes up in your mind, but also this must come through your submissions as well when you make them. But that being said, something else that's very important. Let me just wait. There's something else that's very important to mention, as well as the time constraint. Honestly, and I discussed it with a few of my esteemed colleagues yesterday. It's unbelievable to do everything you've done in such a short period of time. I don't know if I would have been able to, but that's quite impressive. So please, please consider, all of you consider yourselves, that was said by Dr. Bhavna Batra about this, like consider all yourselves as there's no winners and no losers. And I will connect it to a famous decision of the Supreme Court of Canada from 1954, not new, but that makes the exact same point, and that's still applicable nowadays. That's for prosecutors, but the reasoning is very similar to what Dr. Batra told us earlier. Is for the prosecutors, the idea is not to win, not to lose, it's to serve justice. But here, I think it does apply. So you served justice, or the justice in the context of this moot court. And I'm addressing the side who will know that they lose this round, but you don't lose. Everybody in this moot court, in particular in this round, also are all winners. Also consider the time we spent in the deliberation room. Did it take 30 seconds and we came back and we're ready to go? No, it took some time, eh? So that was a tough call, a very tough call to make. I'm telling you, so deliberation was absolutely not easy. So thank you very much for your dedication, your efforts, your also generosity with time, because it's not it's not necessarily I've done a moot court myself. I have to tell you something else to connect it with. I can put myself in your shoes. I have won the first international position of a moot court in 2006. So that's a different millennium, when your grandparents did not even exist. I've won it and I've worked on it every day. There was tension in my team. We argued. We almost fought at some point between each other. So there is tension. Why? Because there is passion. When there is passion, there is emotions, and when emotions are in, sometimes there's tension. That's part of the game. So all of which to say, now it's time to announce who is the winner of this final round. I have to tell you that this is a split decision, which illustrates very easily how difficult it was to determine who won this round. So there is no winner, no loser in the abstract, but we had to decide who is the winner of the final round of this moot court. So I'm very honored and very privileged on behalf of my colleagues and myself to announce that the winner of this moot court is the team of the respondent. Congratulations.
Congratulations.
Thank you. Thank you so much.
Thank you so much, and thank you for taking the time off to judge us. It really means a great deal.
Congratulations, Team Code 20. And for winning Acuity Cyber Moot Court Competition 2021, much deserving, I would say. We would thank all of you for the hard work and efforts you have put into this competition. We all are very grateful for your efforts. Also, dear jury members, we would like to thank each one of you for your interest and involvement in the grand finale round of Acuity Cyber Moot Court Competition 2021. We understand the discomfort you have gone through due to the timing issues, as we live in different countries, and we are very grateful of you all for your presence here. We are honored to have your support, and this competition would not have been possible without you. Thank you so much, judges.